That sounds like a lot of power, but it needs to be used when someone's not cooperating.
And judges don't like when you aren't cooperating. If you're not providing the documents and I have to file what's called a motion to compel, take you to court to get the documents, it just causes my client money unnecessarily. That party that's hiding the ball will likely be on the hook for some of my attorney's fees because we've had to chase the documents. And it does happen a lot.
There's a way to see that it's done fairly. Tell us a little bit, what are like the main steps involved in the divorce process?
I mean, the proper way is that you would file the petition for dissolution of marriage and serve it on the other party. They would have 20 days to respond, probably file their own counter petition. Most counties, it's a requirement that you go to mediation before you litigate, unless there's an emergency, obviously. I find most cases really can resolve at mediation. I believe in mediation. We have a lot of great mediators in town, but they don't always resolve. And so I've actually been litigating a lot more recently, and I don't know why that is. I don't know what's going on in the air right now, but I'm having a harder time getting to resolution, and it's been since post-COVID, and it's just something, a lot more trials.
I'm curious, are there steps, if I'm getting a divorce, are there steps that I should take prior to filing a divorce to make the process smoother?
Well, I like to be as amicable as possible. So I think, talking to your spouse, if it's not a high conflict case, talk to your spouse, try to figure out what you want. Obviously we have what's called mandatory disclosure in every divorce case, which is just an exchange of financial information. And in most cases, we have to do what's called a financial affidavit. So it may help you to start gathering that information. It certainly helps the attorney if you've gathered all of that information and organized it in a way that we can use it. It's very helpful to me and my paralegal when we get all the financial information that's already organized.
You're leading right into my next question, which really is, what records should I take with me to my first appointment with my divorce attorney?
You really don't need to bring anything with you to your first appointment. But it also can't hurt to look at that mandatory disclosure checklist, start gathering your tax returns, pay stubs, bank records, credit card statements. Something people forget is a lot of us have this virtual currency now, like Cash App and PayPal. Gather those records. I do everything electronically if I can. So for me, my preference is I don't even need a piece of paper. Pretty much everything is electronic these days. And in fact, we are filing everything electronically these days. Your marital settlement agreements, everything, we don't have hard copies. It just goes straight into the cloud to the clerk of court.
Wow. So it's becoming easier. I guess if I'm the party in the relationship that doesn't typically handle the finances, like in our family, how would I go about getting copies of the bank records and credit card statements if, like, maybe we're not communicating really well?
Right. So there's a number of things we can do. One, you're entitled to know what everything is, and your spouse has a duty to provide that information. So if you don't have access, they're having a duty to provide it to you. Sometimes people are hiding the ball, and I have the power to subpoena records directly from the banks. If we can't find the information, if they're not providing it, or if we think that they're hiding accounts, I can go straight to the source and subpoena the records.
That sounds like a lot of power, but it needs to be used when someone's not cooperating.
Right. And judges don't like when you aren't cooperating, because, if you're not providing the documents and I have to file what's called a motion to compel, take you to court to get the documents, it just causes my client money unnecessarily. And that party that's hiding the ball will likely be on the hook for some of my attorney's fees because we've had to chase the documents. And it does happen a lot.
There's a way to see that it's done fairly. I guess when you speak to people, what are their primary concerns they might have when going through the divorce? Well,
again, it's sort of case specific. For me, obviously if there's children involved, that's the most important, is what are we doing for the children? What are we trying to do? What is the time sharing schedule going to look like? We have an administrative order in Orange County that talks about, immediately it's going to be a shared parental responsibility case. Both parties need to be exercising time sharing. And if there's some reason that you're not doing an equal time sharing schedule, you better be prepared to prove that up for the court. Because we now have a new statute in Florida that talks about equal time sharing, and I'm paraphrasing, but equal time sharing the presumption is it's in the best interest of the children, is equal time sharing. It is a rebuttable presumption because it's not every case that equal time sharing will be. And in fact, I've already litigated a case since the statute that I was able to overcome that presumption. Protecting assets. If you have a concern that the spouse is, has been preparing for the divorce and trying to hide money, the admin order talks about that too, like preserving assets. It can get challenging at times because I find that our judges don't look at financial matters as emergencies. And if you have the spouse who's not the breadwinner and the other party's kind of trying to starve them out, it can be very challenging that you're trying to get to mediation as quick as possible to address these issues. Because again, we're supposed to mediate before we litigate.
That's tricky, especially when it comes to, I don't have the money to support what I need to do this week.
Right.
That's a challenge.
Right.
So I always hear the phrase, that's grounds for divorce.
Pretty much all of our petitions essentially just say the marriage is irretrievably broken, and that's the grounds for divorce. At the final hearing, the judge may want a quick statement as to why is the marriage irretrievably broken? And it can be as simple as my spouse and I can no longer live together. It doesn't need to be some drawn out thing.
So we don't necessarily have to go through the Judge Judy process.
Right.
It can be, this is where we are in our relationship and we're ready to move on with life.
Right. It's just a pretty simple statement that the marriage is irretrievably broken.
So it's not like one person did this and they'll have a stronger case and maybe to have a better outcome. It's not necessarily going to work that way.
Not necessarily. I mean,